Will the parties in the Greta Hedin case please come forward? Are you Mr. Brenner? You can sit right there. Please call the first case of the morning, Ms. Rubalcaba.
Our first case this morning is Greta Hedin, case number 18042858.
Good morning, everyone, and welcome to the Office of Tax Appeals. My name is Jeffrey Margolis, and I am the lead judge in today's hearing. With me are my co-panelists, Jeff Angija and Amanda Vasic. Although I am the lead judge for purposes of running today's hearing, my co-panelists and I will all have an equal say in deciding the outcome of this case. Before we go on the record with our court reporter, let me briefly explain what the OTA does and today's hearing process. The OTA, that is the Office of Tax Appeals, is an agency that is independent from the FTB. We provide a forum in which taxpayers can have their disputes with California tax agencies resolved fairly and economically consistent with California law. Today's hearing will allow both sides to argue the case and to tell their side of the story and to create an evidentiary record that the panel will base its decision upon applying California law. If at any time you are confused about the process, please feel free to ask me questions. I've gone over the process with you at our pre-hearing conference, so I think everyone should know what is expected of them today. As for presenting your position and your arguments, the panelists already have familiarized themselves with the briefs and the facts. So if you think you've already adequately made your points in your briefs, please don't feel like you have to go over each and every one of them today in your arguments. We will ask you to stay within the time limits that were set at the pre-hearing conference. When we go on the record, I will ask the parties and the representatives to introduce themselves for the record. Then I will make sure everyone agrees on what the issue is that's up for decision by the panel. Next, we will move to the evidentiary phase of the hearing. During it, you will have the opportunity to submit evidence and normally witnesses, but in this case, the parties have both said they don't have any additional witnesses or testimony to provide. After the evidentiary record is complete, you will be permitted to make your arguments. The taxpayer will go first. He's been allocated 15 minutes, and then the FTB will go second with 15 minutes. Then the taxpayer will be able to make a 5-minute closing response. Does either party have any questions about the hearing process before we go on the record? Okay. Are there any last-minute issues or documents that you want us to consider? I do note we did receive a copy today of an additional exhibit from the taxpayer. I've had a chance to look at it briefly, and we can discuss that when we go on the record. Is there anything else that you want to submit today, or? Okay. Okay. Let's go on the record then. We are on the record in the appeal of Greta Hedin, OTA case number 18042858. The date is March 26, 2019, and this hearing is held in Sacramento, California, before Judges Jeffrey Margolis, Jeff Angija, and Amanda Vasic. Will the parties and their representatives please identify themselves for the record, starting with the taxpayer? Okay. And could you spell your last name for the court reporter?
Brenner.
Thank you. For the FTB?
Meera Patel for Franchise Tax Board. That's Patel. And I'm here with Maria Brosterhouse as well.
Okay. The issue in this appeal that I believe is in dispute, and I want to make sure the parties agree, is whether appellant is entitled to a refund of an overpayment that exists in her 2006 account. Is there any objection to that statement of the issue?
No.
No objections.
Okay, thank you. And at the pre-hearing conference, both parties indicated they do not intend to call any witnesses. Is that still correct?
Correct.
Okay. Well, let's go over the exhibits that the parties asked to be admitted into evidence today, starting with petitioner's exhibit. I believe that the only exhibit we have is the claim denial notice, and there's no objection to that. Is that correct?
That's correct.
Okay, that will be admitted as Exhibit 1. And then the FTB had several exhibits labeled Exhibits A through G. Mr. Brenner, at the pre-hearing conference, you said you had no objection to those. Is that still correct?
That's correct.
Okay, we will admit Exhibits A through G into the record. Next, Mr. Brenner, it's time for you to make your argument.
Well, ours is of a hardship case. We've turned in the timeline for her situation, including the homelessness. And
Oh, I'm sorry. I overlooked one thing. There's this additional exhibit. FTB, do you have an objection to this coming into the record?
No objections for the timeline and the statement from Mr. Joyner as well.
Okay, thank you. Excuse me for interrupting.
yeah, so we have included a timeline that shows generally what happened and how it took place with her homelessness, etc., her hardships, and her inability to respond to the notices. Also, we have included the ex-boyfriend's letter stating that he had made the payments on the mortgage and that she had no filing requirement originally, and that the Franchise Tax Board had taken that mortgage interest, times it by 4, created a taxable event, and continued to make collections, furthering her hardship. She currently resides in a low-income housing, Section 8 apartment, Social Security. That's her only income. She never has gone back to work since 04 or 5. So ours is a hardship type situation, and we're asking or requesting some leniency here in the timeline for the repayment.
Okay, thank you. Is that the end of your statement? Ms. Patel?
Ms. Hedin filed her 2006 claim for refund on May 15, 2017. FTB denied her claim for refund because it was not filed within the statutory period. California law requires that taxpayers file a claim for refund within 4 years of the due date of the return or 1 year from the date of payment, whichever is later. Furthermore, the law does not provide for a waiver, exception, or any exception based on financial hardship to the statutory period. In this case, 4 years from the due date of the return would have been April 15, 2011, and 1 year from the date of the most recent payment would have been September 11, 2015. Therefore, the later of those two dates, September 11, 2015, would have been the deadline for Ms. Hedin to file her claim for refund. However, she filed her claim for refund more than a year and a half later. Furthermore, there's no other document that Ms. Hedin filed during this time period that could be construed as a claim for refund. As such, FTB is prohibited by law from refunding Ms. Hedin any overpayment she may have. As stated in OTA's precedential case of Gillespie, even if FTB based a tax on an estimate of income that was later proven to be inaccurate, there is no recourse to refund taxes paid when the claim is untimely. At the pre-hearing conference, Ms. Hedin's representative agreed to the fact that Ms. Hedin's claim for refund was not timely. Therefore, unfortunately, there is no recourse for Ms. Hedin's untimely claim. With respect to the filing enforcement action taken on Ms. Hedin's 2006 account, FTB sent a request for tax return and a notice of proposed assessment to her last known address. In appellant's timeline provided, Ms. Hedin indicated that she lived at the address that the notices were sent to. Furthermore, FTB has no record of the mail being returned. On the facts and evidence in the record, FTB respectfully requests you sustain its position. I'm happy to answer any questions. Thank you.
Ms. Patel, thank you for the information about the address. So could you just state which address the demand notice was sent to and when it was sent again?
So both the request for tax return and the NPA were sent to the 13600 Lake Valley Drive.
13600 Lake Valley.
And so if you look at appellant's timeline, it indicates that she lived at that address from 2005 to 2009. and both those notices were sent in 2009.
Okay. Thank you very much. Do you have any questions for either side?
No.
Mr. Brenner, you have an opportunity to make a short rebuttal if you'd like.
Well, the 2009, she was at that address, but she left there in the end of 2009 for Bakersfield, and then Garden Valley, and then in 2014, that house was sold under lien, or under she couldn't make the payments, and then the Franchise Tax Board's lien had taken place then, and she was homeless yet through 2016, and I'm not sure she got all those notices or understood exactly her rights.
Okay. Okay. We've now received your evidence and arguments. The record in this case is now closed. In a moment, we will adjourn, and the judges will meet to decide this case, and they will send you their written decision within 100 days from today. Is there anything further from the parties?
Nothing further.
Okay, thank you. With that, this hearing is adjourned. We will now take a 5-minute recess, and the next case will set up. Ms. Rubalcava, what's the next case? Not showing up? Okay. Yes, well, the William Llanos parties. Andrew? Are the parties ready to begin?
Yes.
Yes.
Okay, Ms. Rubalcava, will you call the next case, please?
Our next case is William A. Llanos, case number 18010692.
Good morning, everyone, and welcome to the Office of Tax Appeals. My name is Jeffrey Margolis, and I am the lead judge in today's hearing. With me are my co-panelists, Neil Robinson and Andrew Quee. Although I am the lead judge for purposes of running today's hearing, my co-panelists will all have an equal say in determining the outcome of this case. Before we go on the record with the court reporter, please let me briefly explain what the Office of Tax Appeals does in today's hearing process. The Office of Tax Appeals is an agency that is independent from the FTB. We provide a forum in which taxpayers can have their disputes with California tax agencies resolved fairly and economically consistent with California law. Today's hearing will allow both sides to argue their case and tell their side of the story and to create an evidentiary record that the panel will base its decision on applying California law. If at any time you're confused about the process, please feel free to ask me to stop and explain. I've gone over this process with the parties at our pre-hearing conference, so they should know what is expected of them today. As for presenting your position and arguments, the panelists already have familiarized themselves with the facts and the law. They've read your briefs and the exhibits that were submitted with them, so if you think you've already adequately addressed your arguments, you don't need to restate them here today. We will ask you to stay within the timelines that were set at the pre-hearing conference for your arguments. When we go on the record, I will ask the parties to introduce themselves for the record. Then I will make sure everyone agrees on what the issues are that are up for decision by the panel. Next, we will move to the evidentiary phase of our hearing. During that phase, you will have the opportunity to submit exhibits. You will also have the opportunity to provide witness testimony, but at the pre-hearing conference, both sides indicated they did not intend to call witnesses today. Once the evidentiary record is completed, you will be permitted to make your arguments. The taxpayer will go first, and they will have 15 minutes to make their arguments. Then the FTB will have 15 minutes to respond. Finally, the taxpayer will have 5 minutes to make its reply argument. Does either party have any questions about the process before we go on the record?
No.
No questions.
Okay. Does either side have any additional exhibits that were not submitted in accordance with our pre-hearing conference deadlines?
Well, we want to make sure that you have the exhibits that were submitted after the...
Yes, I have exhibits 11 through 18 that were submitted to us. Yes.
Yeah, we don't have anything new other than that.
Okay, great. Thank you for complying with the deadlines.
Yes.
Okay, let's go on the record then. We are on the record in the appeal of William Llanos, OTA case number 18010692. The date is March 26, 2019, and this hearing is being held in Sacramento, California, before Judges Jeffrey Margolis, Andrew Quee, and Neil Robinson. Will the parties and their representatives please identify themselves for the record, starting with the taxpayer and his representative?
William Llanos.
Yes?
David William, representative for the taxpayer.
Mr. William, you appeared before the Office of Tax Appeals in February, and you identified yourself as David Polk. I just want to make sure we have your proper name and address in the record here today. What is
David William Polk.
It's David William Polk, and how would you like me to refer you today? As Mr. Polk or as Mr. William?
Either one is fine.
Okay. And also, I want to make sure we have your correct address, because the address on your power of attorney in this case is different than the address in the power of attorney in the Janelle Polk case.
All right. I'm sorry, what do you have?
Well, in this case, it says care of West Burbank Boulevard, number 262, Burbank, California. In the Janelle Polk case, it said 916 West Burbank Boulevard, Suite C.
Yeah. The address, it's the same address. It's just written incorrectly. I'm trying to find it is 916, the 262. It's 916C West Burbank Boulevard, number 262.
So there's no Suite C? Is it Suite C as well?
Yeah, the C goes on. It's 916C.
Oh, 916C West Burbank Boulevard.
Correct.
Okay.
Yeah, sorry. I guess that was just written incorrectly.
And then is there a number 262 as well?
Yes.
Number 262. Okay, we'll make that change in our records for this case. And Mr. Llanos, just want to make sure, so you want to proceed here today with Mr. Polk as your representative, correct? Okay. Would the FTB please identify themselves for the record?
Sure. Andrew Amara for Franchise Tax Board, and then I'm here with Nancy Parker as well.
Okay, thank you. The issues in this appeal, as agreed to in the pre-hearing conference, are, as I understand, the following. Whether FTB's proposed tax assessment for 2012 is proper and correct. Second, whether appellant is liable for the late filing and demand penalties proposed by the FTB. And third, whether a frivolous appeal penalty should be imposed, and if so, in what amount. Do the parties agree that that correctly states the issues to be decided today?
Yes.
Yes.
Correct, Judge.
Thank you. And at the pre-hearing conference, both parties indicated that they did not intend to call any witnesses. Is that still correct?
Correct.
Okay. Now let's go over the exhibits that the parties asked to be admitted into evidence today. Let's start with petitioner's exhibits. Petitioner's exhibits 1 through 10, I believe there was no objection by the respondent to any of those. Is that correct?
Correct, Judge.
Okay, those exhibits will be admitted. Then there are some new exhibits. Exhibits 11 through 18. What's the FTB's position on these exhibits?
We don't have any issue with those, Judge.
I do have a problem with two of these exhibits in that they kind of circumvent our rules. The declaration of Mr. Llanos. Mr. Llanos is here he could testify here. We don't allow out-of-court declarations, and as you may recall, we kept out the declaration at your request of Mr. McDonald. So I think for fair play that we should keep, that if someone's not going to be here to testify, he is available to testify if you want, but I'm not going to allow his declaration into evidence.
And we admit it as argument.
Yes, we can admit it as argument.
Okay, that's fine.
And also you submitted additional briefing in terms of Exhibit 16. That circumvents our rules on filing additional briefs. You didn't ask for permission to file additional briefs, and as you'll recall at our pre-hearing conference, when Mr. Amara asked for permission to provide additional authorities for us, I told him that I didn't want them submitted in the form of an additional brief. I just wanted him to mention them at his argument if he thought they were significant. And I ask that you do the same with respect to the authorities that you raised in Exhibit 16.
Well, due respect, Judge, the FTB is allowed to submit legal arguments as argument. They have a memo with...
You are allowed to submit them, but you need to submit them in accordance with our pre-hearing rules about submitting briefs.
Okay.
So
Okay.
I'm going to exclude those. Other than that, Exhibits 11 through 15 and 18 will be admitted without qualification. Exhibit 16 will be excluded, and Exhibit 17 will be admitted as argument.
Sorry, Judge, just for the record, I want to object to your keeping out Exhibit 16 because it goes to the, just for the record, just want to object. It goes to the reasonableness of the appellant's position and his determinations.
Okay, your objection is duly noted for the record.
Okay.
Let's move on to the FTB's exhibits. At our pre-hearing conference, I indicated that I would admit Exhibits A through V, as well as A through U, as well as Exhibit X. And I know that Mr. Polk, you made several objections. I will note them for the record for you. With respect to Exhibit F, appellant's protest. Oh, no, no, I'm sorry. Exhibit F, I agreed to sustain your objection to the protest. That will be excluded.
Judge, can we just go on the record indicate our position on that Exhibit F, or I can wait until you get through everything.
I'm sorry. No, you may go on the record.
Sure.
Just please be brief.
I will. We would contest the lack of admissibility of that Exhibit F. That's appellant's protest. There's a statutory protest process that FTB is required to follow. Revenue and Taxation Code Section 19041 and 19045. That goes to not only full due process here, but it shows that the entire appeal process was followed by FTB. So our position is that that protest correspondence should come in because it's, again, it's relevant to show that the entire appeals process accorded to taxpayers was followed. And then also it's relevant to the frivolous appeal matter that is under consideration here as well. So I just want to go on the record on that.
Okay, thank you. Our ruling stands on that, but you're certainly permitted to make your objection for the record. With respect to Exhibit H, I believe Mr. Polk, you object on the grounds of relevance, and I'm overruling that objection. With respect to Exhibit I, the employer's declaration verifying wages, I am excluding the declaration, but I'm admitting the W-2 as a business record.
Would you like me to wait?
You're objecting to that on the grounds of relevance,
Yeah.
I believe?
Yeah, I'm objecting to the W-2 form. That's a new objection, but we already have a federal wage transcript in the exhibits with the same information, so it's redundant, and I don't see that it proves anything beyond. And also, we have an admission that the money was received, so I'm just not sure what the W-2 is supposed to prove.
Okay, your objection is overruled. Next, with respect to the EDD wage record, Exhibits J and K, and the 2012 wage and income transcript, at the pre-hearing conference, you raised no objection, but since that time, you filed a statement of objections to those exhibits.
I withdraw the objection to Exhibit K. We have no objection to that.
Okay, that'll be admitted.
However, J, the EDD wage record, it contains the same information as the federal wage and income transcript and the W-2, so it's redundant, and just don't know what that's supposed to prove.
Okay, I'm going to admit it as a business record, and I'll overrule your objection. Let's move on to Exhibit L, the law summary. At the pre-hearing conference, I said that we will exclude it. We'll allow it only as evidence that it was mailed to the taxpayer, mailed and received by the taxpayer. Okay. That's my ruling on that. With respect to Exhibits M through Q, those are demands for prior year's tax returns. You objected on the grounds of relevance. I'm overruling that objection. I think they are relevant. Exhibits R and S, there was no objection, and those will be admitted. Exhibit T, the Form 10540 for the tax year 2015, you objected on the grounds of relevance. At the pre-hearing conference, I indicated I would overrule that objection, and I am overruling that objection. Exhibit U and X, you had no objection to, and those will be admitted. And you have objections to Exhibits V and W on the grounds of relevance. And I agree to sustain your objections to Exhibit V and W.
Okay.
Mr. Amara, do you want to be heard in any of those other exhibits?
Just with respect to Exhibit I, the declaration, our position is that the declaration authenticates and provides credibility for the attached W-2. So it's relevant in that respect, and it can come in even for that limited purpose. Other than that, no, nothing else.
I just want to make clear that I'm allowing the W-2 to come in as a business record already, so
Sure.
That's why I'm excluding the declaration. Okay, the exhibits that I've that I've said will be admitted will be entered into the record.
And for the record, I just want to object to all of your overrulings. Just
Okay, that's
for the
fine.
record.
That's fine. Your objections are noted. Now, each side will have 15 minutes to make its arguments. Mr. Polk, you may go first.
Thank you. I want to raise a point that's not in the briefs, but it's an important point. The NPA is invalid and should never have been issued. Revenue and Taxation Code 19087 authorizes an NPA when the taxpayer fails to file a return. In this case, FTB's Exhibit B shows that the appellant timely responded to the demand for a return. On page 3 and 4 of that exhibit, you can see that he provided a tax return. The heading on page 3, middle of the page, clearly says return of tax, and that document meets the 4-part test for a valid tax return established by Beard v. Commissioner. Number 1, it purports to be a return.
Mr. Polk,
Yes.
our court reporter has asked me to ask you to slow down a little bit.
We had
so
this
she
problem
can-
last time. Sorry. I'll slow it down a bit. Apologies already. Your fingers are going to get sore. Okay, number 1, it purports to be a return. Number 2, it has sufficient data to calculate a tax liability. It is I'll keep an eye, just let me know. It is an honest and reasonable attempt to comply with the law, and it is signed under penalty of perjury. The FTB ignored this return and sent a second demand notice, that's Exhibit C, claiming that the appellant had not filed a return. And the appellant replied to say he had filed a return and told FTB if there's something wrong with what he had filed to let him know and he will fix it. The FTB ignored this response and issued the NPA. So the appellant did not fail to file a return. The FTB failed to acknowledge his return and failed to acknowledge appellant's response to the second demand notice offering to cure any defect in his tax return.
Mr. Polk, excuse me, did he respond to the first demand?
Yes, with the tax return. That is Exhibit
Exhibit B.
Exhibit D. Oh no, I'm sorry. Exhibit B. That's FTB's Exhibit B.
Okay.
Is the timely response that contained a tax return. So the required conditions of RNTC 19087 were not met. All right, moving on, and this is going to expand a bit on what's in the briefs, but the preponderance of evidence shows the NPA is wrong. The FTB relies on appellant's admission that appellant received money from Space Systems Loral, I'll call them SSL, and that he received money from Citigroup. Now, contrary to common misconception, that is not sufficient factual basis to conclude that the money is included by law in gross income and therefore taxable. The FTB cannot just assume that the money he received is included by law in gross income. As the U.S. Tax Court stated in Liddy v. Commissioner, it is well settled that the mere receipt and possession of money does not by itself constitute taxable income. The distinction between earnings that are taxable income and those that are not is recognized in the Code of Federal Regulations 1.61-2, where it lists several types of earnings and states that these things are income to the recipients unless excluded by law. The regulation does not say unless excluded by a provision of Subtitle A or of the Code. It says excluded by law. That could be an exclusion under any law. How could earnings be excluded by law from income? Many federal cases refer to the need to connect the taxpayer to a taxable income producing activity in order to conclude there is unreported gross income. For example, the Third Circuit in Anastasato v. Commissioner stated, given the obvious difficulties in proving non-receipt of income, we believe the commissioner should have to provide evidence linking the taxpayer to the tax-generating activity in cases involving unreported income, whether legal or illegal.
Could you spell that case for our court reporter?
Yes. Anastasato. Anastasato, the commissioner. Also, that we're going to have fun with this one. The Ninth Circuit in Weimerskirch v. Commissioner. Do I need to spell that? Yes. Weimerskirch. Weimerskirch v. Commissioner. Ninth Circuit in that case said there must be some evidentiary foundation linking the taxpayer to the alleged income-producing activity. So the appellant determined that there has to be evidence linking the taxpayer to a federally taxable activity. And to further clarify that point, the House Congressional Record of March 27, 1943 states, the income tax is therefore not a tax on income as such. It is an excise tax with respect to certain activities and privileges, which is measured by referring to the income which they produce. The income is not the subject of the tax. It is the basis for determining the amount of the tax. So the appellant determined that the subject of the federal tax is a federally taxable activity or privilege. It is not a tax on money per se, and it is not a tax on everything that came in. The Supreme Court in Eisner v. Macomber, I referenced this case in the briefs, recognized there are earnings that would not qualify as taxable income within the meaning of the 16th Amendment, stating it becomes essential to distinguish between what is and what is not income, as the term is there used in the 16th Amendment, and to apply the distinction as cases arise according to truth and substance without regard to form. This distinction between what is taxable and what is not is recognized at 26 CFR 1.61-1, defining the term gross income, and it states that it means all income from whatever source derived, unless excluded by law. The regulation does not say unless excluded by a provision of subtitle A or a provision of the code. It says excluded by law. That could be an exclusion under any law. And Exhibit 16 has been tossed, so I will just have to refer to this, to these legal authorities. But the Title 26 regulations, current regulations, use various terms to describe income that is excluded by law from gross income. Terms such as income wholly exempt from tax under the provisions of any other law, and income not taxable by the federal government under the Constitution. That's in current regulations. Also Treasury Decision 3146 refers at Article 71 to exclusions from gross income of income that is, quote, by fundamental law free from tax. And I quote further from Article 71, quote, such tax-free income should not be included in the return of income and need not be mentioned in the return unless information regarding it is specifically called for. The exclusion of such income should not be confused with the reduction of taxable income by the application of allowable deductions, end quote. How's my speed? Okay.
Mr. Polk, which law are you saying specifically excluded it?
Treasury Decision 3146.
Okay.
That's what I'm citing. And I'm going to expand on that point.
3146, that's the basis.
Treasury Decision 3146 is what I'm quoting from. The appellant determined that the money he received is not included by law in gross income. Despite admitting he received the money, he never expressed any certainty that the money is included by law in gross income, and he ultimately determined that if he cannot be certain that it is included by law in gross income from his reading of the law, then by default it is excluded by law from gross income. This is due to the well-settled rule of construction established by the Supreme Court in Gould v. Gould, G-O-U-L-D, where they said such taxing statutes are not to be extended by implication beyond the clear import of the language used. If the words are doubtful, the doubt must be resolved against the government and in favor of the taxpayer. Also in Spreckles Sugar Refining Company v. McLean, the Supreme Court said the well-settled rule, the citizen is exempt from taxation unless the same is imposed by clear and unequivocal language, and that where the construction of a tax law is doubtful, the doubt is to be resolved in favor of those upon whom the tax is sought to be laid. The appellant relied on these rules of construction for taxing statutes to determine that he is exempt from taxation on that money and that he is entitled by law to exclude that money from the gross income on his return. Per Treasury Decision 3146, a tax return does not require a taxpayer to mention any money that is excluded by law from gross income. And very significantly in this case, the IRS has agreed with his determinations and has removed the previously assessed federal tax. The IRS took more than a year after the appellant filed his return before they did that. It might be very hard to accept that they did that, but they did it. There is no basis in fact or law for the FTB's claim that this was a mistake by the IRS. This was not a mistake. The IRS simply followed the evidence and the law. The federal account transcript at Exhibit X on page 2, you can see that on June 5th, 2017, the IRS removed $30,850 of tax based on audit reconsideration after the appellant filed a return, April 15th, 2016. So the IRS took more than a year to decide to agree with the appellant's determinations. And it has been nearly 2 years since then, and they have not changed those determinations. Now, the federal AGI reported on appellant's state return at Exhibit 5, which FTB claims is invalid, is exactly the same amount of federal AGI shown in his federal records at Exhibit X. So I don't know what else he's supposed to put on his state return. for federal AGI when the IRS agrees with him. It is obvious from federal cases such as Portillo v. Commissioner and in SBE and OTA cases that a taxpayer's determination of his gross income on a valid filed tax return is presumed correct. Cases show that the FTB has been given wide latitude to rely on EDD reporting and W-2 forms, but only when no valid tax return has been filed. The FTB claims that the federal AGI on appellant's tax returns and in federal records is wrong because the FTB claims the money appellant received is included by law in gross income. That is a jurisdictional claim that the FTB is making that is contrary to filed tax returns and contrary to federal determinations. Such a claim requires evidence of sufficient jurisdictional facts. The FTB has not produced evidence of sufficient jurisdictional facts. If the FTB is correct that this money is included by law in gross income, then probative evidence of that should be available from the third parties who issued these information returns the FTB relies on. But FTB did not ever contact Citigroup to verify the info on the 1099-R issued by Citi, and FTB did contact Space Systems Loral, but FTB has failed to produce probative evidence as to the issue of whether the money is included by law in gross income. The FTB has produced nothing to assuage doubts as to the accuracy of the legal determinations represented on the W-2 form. The appellant is thus entitled to a presumption against the FTB. Per the appeal of Don Cookston, 83 SBE 048, the failure of a party to introduce evidence that is within his control gives rise to a presumption that such evidence is unfavorable to his case. If such evidence existed, then they could have, should have, and would have produced it. If the FTB is correct, they had ample opportunity to obtain that evidence, but they did not. They just assume the tax return is inaccurate. They even claim without basis that the return is invalid, and they assume that the federal determinations are erroneous. FTB has made the same error that IRS made in Portillo v. Commissioner. The FTB has arbitrarily attributed veracity to unverified third-party reporting and assumed the taxpayer's return is false, just as the IRS did in Portillo. The federal courts recognize that information filed by a third party are not conclusive evidence of gross income. As the district court stated in Daines v. Alcatel, that's D-A-I-N-E-S, v. Alcatel, A-L-C-A-T-E-L. The court said, an informational return is filed by a third party, which reports income as that third party believes it to be. The Internal Revenue Code makes it clear that an information return is not the final word on what a taxpayer's taxable income is, as provided in 26 U.S.C. 6201D, in any court proceeding if a taxpayer asserts a reasonable dispute with respect to any item reported on an information return by a third party. The IRS shall have the burden of producing reasonable and probative information concerning such deficiency in addition to the information return. The appellant's dispute of the W-2 and 1099-R reporting is reasonable. These forms represent legal determinations that the money that was paid is included by law in gross income. The appellant determined that those legal determinations are arbitrary and incorrect. The United States District Court in David Nelson v. United States of America ruled that the taxpayer in that case had failed to assert a reasonable dispute, quote, because the taxpayer did not dispute that the remuneration he received was wages and therefore taxable. The court was clearly recognizing that a dispute of a claim that remuneration received is included by law in gross income and therefore taxable would be a reasonable dispute.
Mr. Polk, I know you only have 2 minutes left,
okay.
But if you can still slow down.
Oh, all right, sorry. All right. The Portillo court said, quoting, Carson v. United States, the need for tax collection does not serve to excuse the government from providing some factual foundation for its assessments. The tax collector's presumption of correctness has a Herculean muscularity of Goliath-like reach, but we strike an Achilles heel when we find no muscles, no tendons, no ligaments of fact. The FTB has produced no ligaments of fact to support its claims. Furthermore, they assume that the federal determinations are erroneous. Now, the FTB is not bound by law to follow federal determinations, but federal determinations are presumed correct when the FTB bases its determinations on them, per the appeal of Willard D. and Esther J. Schollerman. Boy, lots of fun names today. S-C-H-O-E-L-L-E-R-M-A-N. That's SBE, September 17, 1973. Now, if the previous federal determination were still standing, the FTB assessment, based on that, would be presumed correct, and the appellant would have the burden to show that it's wrong. So effectively, federal determinations are presumed correct. So now that the federal determinations have changed, why wouldn't those Fed determinations be presumed correct now? because the FTB doesn't like what it says? The federal determinations are entitled to at least a rebuttable presumption of correctness. The FTB is not bound by them, but they cannot arbitrarily disregard them. They are arbitrarily disregarding them. They have to have basis in fact or law to support their claim that the federal determinations are erroneous, and they cannot prove that by just simply alleging that they are erroneous.
Okay, thank you. Your 15 minutes are up.
All right.
Mr. Amar?
Sure, Judge. Before I go into my summary of the case, I just want to direct your office to a recent U.S. tax court case called Hendrickson versus Commissioner. The site is TC Memo 2019-10. That's a February 2019 case that's directly on point with this, with the issues in this case. And I'll just briefly take you through a couple key portions there. First of all, the litigants in that case received wage and 1099 income. The approach, so to speak, that they took is again directly on point with what's occurring here. They submitted, this is page 4 of the opinion, they submitted amended Forms W-2 zeroing out the wages reported by their employer, and then they submitted corrected 1099 forms as well. The court in addressing, and then they filed essentially zero returns in that case. The court in addressing what occurred there indicated this use of zero return, zeroing out wages and compensation, and reporting zero liability has been repeatedly characterized as frivolous. That's page 5 of the opinion. And then further on, the court squarely addressed those arguments and said that the litigants' tax protester arguments have burdened the judicial system and the IRS for nearly 3 decades. Their use of substitute Forms W-2 and quote, in quotes, corrected Forms 1099 miss, as discussed in Cracking the Code, a book where this approach is laid out, and used by the taxpayers in a different case, have been repeatedly rejected by the court. They go on to state this frivolous argument is not new to the court and will not waste judicial resources addressing it further. And then one other thing that's relevant to this case, the litigants in that case submitted zero returns or returns showing minimal income but not containing the the correct wage and 1099 income. The court indicated the IRS is incorrect. The IRS in that case incorrectly processed those returns. They indicated the processing of an invalid return does not make it valid. As the court in response to that issue. So I just wanted to highlight that case because it's directly on point with this case. And it's a recent opinion. Now, getting to this case, as you're aware, this is a 2012 case involving unreported income and penalties. The reason we're here is because appellant refuses to accept that his 2012 wage and 1099 income is taxable and creates a filing obligation. This classic frivolous argument is insufficient to overturn FTB's action in this case. With respect to the burden of proof here, as is set out in FTB's briefing, the FTB's assessment is presumed to be accurate, and appellant must demonstrate error in the assessment to prevail. There are penalties in this case as well, and appellant has to establish reasonable cause for failing to timely file a return and or respond to the demand notices in this case, the demand notice. Now, getting to the key facts in this case, the dispute is relatively basic. There's no real dispute that appellant received income for his services with his employer in 2012, and he received 1099 income as well. The crux of the case is, and appellant's entire case, rests on his semantic argument that the income he received was somehow misclassified and that it's not taxable or reportable on that basis. This is an often repeated frivolous argument or variations on that argument. It's been repeatedly rejected by courts, both the U.S. Tax Court and district courts, the Board of Equalization, and your agency in the Appeal of Home rejected such an argument. It's incontrovertible that appellant's wage and 1099 income is reportable and taxable, and it forms a sufficient basis for FTB's assessment. Appellant has not demonstrated error in the assessment, so it should be sustained in full. With respect to the penalties in the case, appellant does not advance any reasonable cause argument against either of the penalties, and those should be sustained as well. I don't have anything further.
Okay, Mr. Polk, you have 5 minutes to reply.
Yes, the Hendrickson v. Commissioner case, I want to address that. This case is off point. It's inapposite. In this case, the litigant Hendrickson had been convicted of filing fraudulent tax returns, so it was res judicata and established that the returns were invalid, and that makes a huge difference. In this case, the IRS has accepted the appellant's determinations, and that makes a big difference when it is settled that whether it's settled or not that the return is fraudulent or false, as the FTB claims. I want to point out the third-party reporting that FTB relies on has not been substantiated in any way. The appellant has actually offered positive evidence for you to indicate that the W-2 reporting from SSL is not reliable. He's asked SSL multiple times to verify their legal determinations that they represented on the original W-2, and they have refused to respond in good faith. See the email exchange at Exhibit 10. SSL Legal Department flatly refused to discuss the matter and refused to provide him any information. See also Exhibit 13, where your appellant warns SSL that their failure to produce facts and evidence to verify their claims would be assumed to be their admission that the information they reported on the original W-2 is not accurate, and that their representation of gross income paid in the course of a trade or business is arbitrary and without basis in fact or law, and they were warned that this would be presented as evidence at this hearing, at their failure to respond. Again, SSL refused to respond in good faith, making spurious claims that such information is confidential. The appellant is entitled to take that failure to produce evidence as an admission that their determinations are arbitrary and incorrect. SSL had a duty to...
Folks, slow down again, please.
I'm sorry. All right. The SSL had a duty to address his inquiry in good faith. The U.S. Court of Appeals in Fifth Circuit in Clemens v. Revlon found Revlon negligent for failing to correct an erroneous W-2. They found it was actionable negligence. The bottom line, FTB has relied on unverified and unreliable third-party reporting in order to assume the appellant's return is false and assume the IRS determinations are incorrect. The appellant has thus demonstrated error in the proposed assessment. As for the frivolous appeal penalty, there's nothing frivolous about saying, I don't believe this money is included by law in gross income, as it was reported by this third party. That's a legal determination that turns on questions of fact. It's perfectly reasonable to dispute third-party reporting. The IRS and FTB both make forms expressly for that purpose. There's a 3525 form made by FTB and a 4852 form made by the IRS. And those forms do not require the taxpayer to get the third-party filer to agree with the corrections. There is no law preventing a taxpayer from issuing his own corrected form so long as it reflects what he believes is the correct information. That's the issue, is whether the information is correct. The FTB just assumes, again, that the third party, whatever the third party says is correct and whatever the taxpayer says is false. Well, that's very self-serving of them. The appellant had already filed his federal return when this appeal began, and he was waiting for the IRS to adjust his federal tax, which they did. There's nothing frivolous about his position in this appeal. It is supported by 26 CFR 1.61-1 and many other legal authorities. His appeal of the NPA is perfectly reasonable and is supported by the federal determinations that are in his favor. If the state tax had already been assessed at the time the IRS removed his federal tax in 2017, the appellant would actually be required, per FTB publication 1008, he would be required to contact the FTB for adjustment to his state tax. So there's certainly nothing improper about his reliance for this appeal on his federal AGI, on his federal return, and the IRS determinations that agree with him. Therefore, there's no reasonable basis for calling this appeal frivolous.
Okay, do my panelists have any questions of the parties?
I just have one question for the Franchise Tax Board. I'd like just some clarification on the demand penalty. Is the Franchise Tax Board's position that the taxpayer did not respond at all to the demand, or that the taxpayer did timely respond to the demand but provided an invalid return so the response was not accepted?
Our position is that the response was insufficient in that it didn't constitute a return, and it didn't address the income that was underlying the demand for the tax return. So FTB responded to the initial response by saying, please file a valid return. That's Exhibit C in the record. Appellant again failed to file a valid return in response, and so the demand penalty was imposed.
Okay, thank you.
Sure.
If I may interject, it is your role as the board to decide whether the return was valid or invalid. The FTB obviously decided it wasn't. I think the case law does not support their position.
Thank you.
Okay. Is there anything further from the parties?
Just one thing with respect to the frivolous appeal penalty. I just want to direct your attention to Exhibit U, page 8 of Exhibit U, which is there was a prior frivolous appeal penalty imposed against appellant that was a 2010 case, I believe. And then page 8 of that.
We're aware of that. The $750 penalty, I believe.
Sure. And I just want to highlight that in bold letters, in bold print at the end of that summary decision, it indicates appellant should be aware that we will not hesitate to impose a higher penalty up to the statutory maximum of $5,000 per appeal if he pursues further frivolous appeals.
Okay. Mr. Polk?
Yeah, no
briefly.
question. The previous appeal was frivolous arguments. That should not prejudice him for making a valid appeal, as he has done in this case, and supported by federal determinations.
Okay, thank you. With that, this hearing is adjourned. We will take a 5-minute recess while we set up for the next hearing.
Thank you.
Thank you. Mr. Rubalcaba, what's the next hearing?
The next case on the agenda is the appeal of Jeffrey G. Sandoval, case ID number 18043037. Appellant has indicated that he's waiving his appearance. Therefore, the matter is removed from the agenda and the appeal will be decided based on written record. So we'll go ahead and move forward with Thomas M. Purbaugh and Karen M. Spina.
No. Good. I'm Brad. Hi, Brad. Chris, nice to meet you. Parker. Chris, nice to meet you.
Okay, good morning. This is the appeal of Thomas Purbaugh and Karen Spina. Welcome. I am lead administrative law judge Sarah Hosey, and with me today is Judge Tommy Leung and Judge Jeffrey Margolis. Can I have the parties introduce themselves, please?
Chris York.
Thank you, Mr. York.
For the Franchise Tax Board, Brad Catino, and to my left is Nancy Parker.
Okay, thank you. Welcome. Right now we're off the record. I'm just going to go over a few housekeeping items, kind of what was discussed at the pre-hearing conference, answer any questions you may have, just so we're all on the same page. Then we're going to go on the record where both parties will have a chance to make their presentations, and our stenographer will begin transcribing. If at any time you're confused during the process or if you have any questions, just please let me know. I am the lead judge for the purpose of conducting this hearing, but all three judges on the panel are co-equal decision makers. We have all read the briefs and examined the exhibits produced thus far. It's just a reminder that OTA is an independent agency. We do not communicate with either party unless the other party is present. Because of this neutral position, we only have the exhibits and arguments provided by the parties on appeal. We discussed this at the March 7th pre-hearing conference, so if we don't have it in your briefs or exhibits, then we don't have it. So do I have any questions at this point?
No.
Okay. The issue before us today is have appellants established reasonable cause to abate the late payment penalty imposed under Section 19132. Is that right, Mr. York?
That's correct.
Great. Mr. Coutinho?
Yes, that is correct.
Thank you. And clarification, the taxpayers are not seeking abatement of the estimated tax penalty. Is that correct, Mr.
That is
York?
correct.
Okay, great. On to the exhibits. The exhibits we discussed at the March 7th pre-hearing conference, I have appellants 1 through 6 and respondents A through G, as in goat. Do I have any new exhibits today?
No.
Okay,
No exhibits.
great. We will enter those on the record shortly. As for the presentations today, Mr. York, you will have 20 minutes for your presentation, followed by Mr. Coutinho, also with 20 minutes. If we don't make that time, that's fine. It was just an estimate. And then, Mr. York, you will have 5 minutes for your final statement. Any questions before we go on the record?
No questions.
Okay, hearing none. Panel, you guys ready to go? Okay. We're going to now go on the record. This is the appeal of Thomas M. Purbaugh and Karen M. Spina, case number 180428889. Today is March 26, 2019, and it's approximately 10 o'clock. We're in Sacramento, California. I am lead administrative law judge Sarah Hosey, and with me today is Judge Jeffrey Margolis and Judge Tommy Leung. Parties, can I please have you state your names for the record?
Christopher York.
Brad Catino for the Franchise Tax Board.
Thank you. The issue before us today is have appellants establish reasonable cause to abate the late payment penalty imposed under California Revenue and Taxation Code Section 19132. Can I get the parties' agreement as to the issue today?
I agree.
Great.
Franchise Tax Board agrees.
Great. Moving on to the exhibits. We pre-marked exhibits 1 through 6 for appellants and A through G, as in goat, for respondent, FTB, at the pre-hearing conference held on March 7th, 2019. Mr. York, do you have any objections to admitting exhibits A through G?
I do not.
Mr. Coutinho, any objections to admitting exhibits 1 through 6?
No objection.
Great. And we have no new exhibits
Correct.
today.
That is correct.
Okay, exhibits 1 through 6 and A through G are admitted as evidence into the record. Okay, Mr. York, are you ready to begin your presentation?
I am.
Okay, please begin.
Great. I'd just like to start with kind of rehashing the facts that took place in the situation. The taxpayers engaged me, the CPA, to prepare their 2015 tax returns. I've been doing their returns and working with this client for over 10 years. The tax data to file a complete tax return was not available, so extensions were prepared on April 18th. The taxpayers had a very large balance due with their extensions due to the sale of a business during that tax year. The CPA offered to have payments made via direct debit from their checking account as part of the electronic filing of the extensions. The taxpayers were on vacation and away from home, so they opted to have the payments made for them rather than having to deal with getting checks written and out in the mail. The taxpayer verified funds were in the account to make sure that the large balances would be covered. The CPA submitted extensions via e-file through their tax software on Monday, April 18th, which was a timely filed extension. On Thursday, April 21st, only 3 days later, still on vacation, the taxpayer called the CPA to notify them that the money was not taken out of the bank account. So they were diligently watching their bank account balances. The CPA researched and discovered that there was a key punch error inside this tax software, and the California payment was not submitted along with the extension. The Fed payment, which was also very large, was submitted as planned. The CPA notified the taxpayer of the issue, who immediately made an electronic payment using the FTB WebPay system to pay the balance due on April 21st, again, only 3 days later. The payment for the unpaid balance was made, and everything was cleared the bank very timely. I mean, ultimately, that's the facts of the situation. It's very simple, very straightforward. A mistake was made, and it was remedied very, very quickly. In the Franchise Tax Board's Exhibit F, they talk about the requirement for abatement. There's two key factors in that. One is the taxpayer exercised ordinary business care and prudence. And number two, the taxpayer acted consistent with an ordinarily intelligent and prudent business person. We believe that the taxpayers fulfilled both of these requirements. They hired a professional tax preparer to assist them with the proper filing of their tax reporting. Millions of people every year hire professional tax preparers, so I think it's something that an ordinarily intelligent and prudent person would do. I would bet that many of the people in this room, including FTB counsel, have engaged CPAs for their tax returns, so I think that's a good thing. The tax code is infinitely more difficult than most people can understand on their own. Hiring a tax preparer is often the only way to file a correct tax return. The taxpayer had a long history of the CPA with no issues or reason to believe that an error would occur. The taxpayer diligently monitored their bank account activity to ensure that the payments were made despite being on vacation. And they remedied the error immediately upon discovery of the problem. They didn't wait, they didn't think, they just acted and paid the bill that needed to be paid. And for all these reasons, I believe that they've acted in accordance with the rules to have the penalty abated. That's all I have.
Okay, thank you, Mr. York. Judge Margolis, do you have any questions?
No.
Okay. Judge Llanos? Okay. We're going to move on to Mr. Coutinho's presentation, and if you're ready.
Thank you.
Okay, please begin.
Good morning. Appellants have not demonstrated reasonable cause to abate the late payment penalty imposed under Revenue and Taxation Code, Section 19132, for the 2015 tax year. As stated in appellant's appeal letter, due to an oversight by their tax preparer, appellants failed to make a timely payment for the 2015 tax year. As stated in FTB's opening brief, a taxpayer's reliance on an agent, such as an accountant or a tax attorney, to pay their taxes by the due date has not been found to be reasonable cause. Further, as stated by your office in the presidential case in the appeal of Sidney Friedman, the failure to timely remit the balance due on a tax liability caused by an oversight does not, by itself, constitute reasonable cause. Accordingly, there are no grounds to abate the late payment penalty in this case, and FTB respectfully requests that it be sustained. I'd be happy to address any questions or concerns the panel may have. Thank you for your time.
Thank you. Judge Lynn, do you have any questions? Judge Margolis?
Yes, Mr. Coutinho, could you explain the computation of the penalty amount here? I'm a little bit confused about what the 5% was applied to, what the late filing penalty was applied to.
Sure. I believe in this case, the late payment penalty was originally calculated to be a higher amount because it did not consider appellant's return payment that was received on April 22nd, 2016. The penalty in this case was calculated as 5% of the total tax unpaid plus 0.5% for every month of the payment of the taxes late, not to exceed 40 months. In this case, the appellant's tax was considered 1 month late, and a $22,863 late payment penalty was imposed. That was calculated on the total tax of $415,000 times 0.05% to be $20,785 plus the 1 month that it was late, and that was 0.5% on the total tax of $415,000 for a total of the late payment of being $22,863. This is more specifically laid out in our opening brief on page 3.
Okay, thank you. I guess I have a question. I've seen lots of briefs from the FTB where the taxpayer makes an error and files late or pays late, and you ask the Franchise Tax Board, and you point out the fact that they didn't promptly rectify it. And here you have a situation where the taxpayer did promptly rectify it. They were monitoring it. The payment was only three days late. Is there any ability, does the FTP have any sort of grace period in this type of situation where even though there was an innocent oversight, there was constant monitoring, and this was paid very promptly afterwards?
Fortunately, there is no grace period in this specific thing. I refer the Office of Tax Appeals to United States versus Boyle. In that case, they said a taxpayer has a personal non-delegable duty to file and pay their taxes on time, and reliance on an agent is a reasonable cause. In that case, it said it may be reasonable for a taxpayer to assume that an attorney or CPA would comply with the statute, but that resolves the matter between them, the taxpayer and the CPA, but it does not absolve a taxpayer of his or her responsibilities under the unambiguous statute. In this case, because it was within the taxpayer's control to submit a timely payment, had it not been within their control, had it been a system error that they were not able, the tax software wouldn't allow them to make a payment, or if there was some type of natural disaster, like such as a fire or something that was outside of the taxpayer's control, such as a serious illness, then it could possibly rise to the level of reasonable cause. However, when it's in the taxpayer's purview and control, that does not rise to the level of reasonable cause.
Well, I guess I'm somewhat sympathetic, very sympathetic to the taxpayer's case here, because here when he made the payment, the FTB's system, or the payment system, I think it sends out a notice saying that we can't even confirm whether or not the payment was successful for another 2 business days. So if a taxpayer pays on April, or thinks they pay on April 15th, there's no way they can check it that day. They can only check it 2 or 3 days later. So here you have a taxpayer who, yes, they made an oversight and an error, but they thought they were definitely constantly monitoring. There's no dispute about that from what I can tell.
Right.
Is there a way your systems can maybe make it so that they can immediately tell if the payment's successful, or?
I'm not aware with our systems of how I would necessarily tell them specifically, but I believe I checked with our e-payment department to see if they could show any record that a payment had been tried to been attempted on that date, and our records reflected that there wasn't an attempt on that date. However, there was a payment made for the 2016 tax year, an estimate payment by the taxpayer for the following tax year, but we don't have records that an attempt was made for the 2015 tax year.
I disagree. There's clearly a payment made 3 days later for the full $449,000.
I think what he's saying is that he doesn't see any documentary evidence that the payment was attempted for the 2015 tax year. Is that what you're saying?
That is correct.
No.
A timely payment on April 18th.
That I agree with. It was supposed to happen on the 18th, but that was accidentally missed. It was paid 3 days later on the 18th for the 2015 tax year.
Okay.
I just want to make sure that's clear.
Okay, my questions have been answered.
Okay. Mr. York, you have time for a final statement if you'd like to. Go ahead.
Yeah, I got a couple of things.
Sure.
First, Exhibit F clearly states that here are ways that we can abate the penalty. The burden of proof is on the taxpayer to establish reasonable cause. How they define reasonable cause I think we've demonstrated that they have reasonable cause based on the two facts that they were acting like a prudent, ordinary businessman, and that they were diligent. Let's see if I use the terms properly there. They exercised ordinary business care and prudence. The taxpayer acted consistent with an ordinarily intelligent and prudent business person. I think they've clearly demonstrated that, which is grounds for abatement according to their Exhibit F. The other thing I'd like to say is that if you cannot delegate the authority to somebody else to pay your tax or file your tax returns, why does the FTB allow third parties to submit tax returns on behalf of taxpayers or allow payments directly from tax preparation software? If they're allowing this to happen, they've obviously allowed the delegation. The whole tax filing system is premised on delegation. So I don't see how this can't be allowed.
Mr. Catino, would you like to
Yes.
respond to that specific question?
While a taxpayer can delegate the authority to have a CPA or an attorney file their tax return or pay their tax return, the code is very clear that the responsibility relies on the taxpayer. And as I stated earlier, the United States versus Boyle states clearly that even though a taxpayer may delegate that, and that may be reasonable for them to do it between those two parties that enter into a contract together, it's not does not absolve a taxpayer's responsibility to make sure that their taxes are paid and filed on time.
Okay.
Mr. Catino, can I ask you a question? If there wasn't a delegation and the taxpayer did exactly what Mr. York did himself, would the FTB still impose a penalty, or would they find the taxpayer's actions to be reasonable?
There would still be a penalty imposed, even if it had been the taxpayer as opposed to the CPA.
Okay.
Right. Mr. York, would you like to add anything else?
Yeah, I guess the Franchise Tax Board's position is that mistakes can't be made. Right? In this case, the taxpayer or the CPA made a mistake. In the case of a taxpayer doing the same thing, they made a mistake. But I'm sure that the Franchise Tax Board has made mistakes, and they stand behind the fact that mistakes happen. So,
Okay. Thank you. We're ready to submit the case. The record is now closed. This concludes the hearing, and the judges will meet and decide the case based on the documents and the arguments presented today. We will aim to send both parties our written decision within 100 days of today. Thank you both.
thank you.
Thank you.
Hearing is now adjourned. We have another case. Okay, so we'll have a 5-minute recess.
Right.
There's no camera. So
Yeah.
screaming, I believe we disembodied voice speaking. So unless people object, I would generally allow members and there's witnesses here.
Will the camera still show us? Make sure you get camera time. And then that's in my contract. Well, retirement's.
Oh, I see. Not just make
second
a.
career as a model or something.
Oh. If anything, I just wanted to make a quick statement.
Ms. Rubalcaba, would you call the case, please?
Our last case for today is Susan Marie Hendrickson, case number 180-63320.
Good morning, everybody. Welcome to the Office of Tax Appeals. Today is March 26th, 2019. We're in our hearing room in Sacramento, and it's approximately 10:23 a.m. We're not going to discuss things off the record in this case. I believe you were all sitting in the audience when my colleague, Judge Margolis, gave a presentation about what we're here for, what OTA is, how we're independent from the taxing agencies. So I'm going to skip those unless somebody has a question about that. I ask them to speak up. And we're going to move right into the case with my brief introduction. Part of it is that our stenographer, Mrs. Perry, as you know, is trying to take down everything that we say to help her and all of us make a clean and understandable record if we ever have to read it. You need to speak clearly and slowly. Do not speak when someone else is speaking, and it's best not to engage in side discussions at your table because your microphones will pick it up. Ms. Perry may hear it, and she may report what is being said. So if you need to talk to your client, it's best to ask for a recess and go outside and do that. As I said, my name is Michael Geary. I am the lead judge in this morning's case. I am joined on the panel by Andrew Quee and Teresa Stanley, who are equal participants, will be equal participants in the deliberation when we discuss the case and weigh the evidence and decide the issues that you are presenting for our determination. We will all participate in that process. Please state your appearances, beginning with the taxpayer.
Rob Goldstein, appearing on behalf of petitioner, taxpayer Susan Hendrickson.
Thank you. And I see Mrs. Hendrickson is with you, correct?
Correct.
All right. And for the California Department of Tax and Fee Administration?
Scott Lambert.
And Kevin Hanks.
All right. And you're joined, I see, by Mr. Smith, Steve Smith at the table. He doesn't have a microphone in front of him, and he's assured me before we went on the record that he doesn't intend to say anything, so that will work out just fine. All right. This is an appeal from an action by the department determining $440,402 of additional tax and applicable interest for the period January 1, 2009 through December 31, 2011. It's my understanding from prior communications during a pre-hearing conference and from reading this file that the appellant contends that she accurately reported her taxable sales, that no additional tax is due, and that she was not negligent. Do we have a negligent penalty in this case?
Oh, we do not.
We do not. All right. The parties agreed at the pre-hearing conference that the issues to be addressed at the hearing are whether appellant is entitled to a reduction of the measure of additional taxable sales. The appellant has offered two exhibits, which we've marked for identification as 1 and 2. They consist of a one-page document, I think, and a 47-page document, the latter being what appears to be a number of invoices. And so far, I've heard no objections from the department, which was to state its objections in writing by March 18th. Mr. Lambert, do you have any objections to any of the exhibits?
I do not. Just one question. Are we on the record now, or are we still?
Yes, we're on the record.
Okay.
We've been on the record since I started speaking, I hope. Yes,
okay.
She's nodding, we are. Okay. There being no objection to the appellant's two exhibits, exhibits 1 and 2 are admitted. The department has also submitted exhibits. They have been marked for identification A through I. They consist of 181 pages. I've received no written objections from appellant. Mr. Goldstein, does the appellant have any objection to the admission of the department's evidence?
No, Your Honor.
All right, thank you. Those exhibits A through I are admitted. Has anybody brought with them today any new exhibits to be offered, Mr. Goldstein?
Not today, Your Honor.
Department?
We have not.
All right. During our pre-hearing conference, Mr. Goldstein indicated that he would probably call two witnesses, his client, Ms. Hendrickson, and another individual who I believe is here today. Do you intend to call those two witnesses, Mr. Goldstein?
I reserve the right to.
All right. We will get to the point at which you will have to make a decision very soon. My understanding is that the department does not intend to call any witnesses. Is that correct?
We have no witnesses.
Before we actually began this proceeding, I was standing in front of the council table speaking with all the parties and their representatives, and I indicated to Mr. Goldstein that if he calls witnesses, he could have the option of having them testify from the witness box or from the table. And I mentioned to the department that if whoever gives the arguments on behalf of the department intends to state any factual matters in argument that they would expect the judges to rely upon, then that argument would have to be given under oath so that those factual matters could be stated under oath during this proceeding. I will leave the decision about whether or not you intend to state any factual matters to you, but when I call upon the department to give its argument, and it will have one opportunity to give an argument, I want you to tell me whether you want to be placed under oath because you do intend to state factual matters that you want the judges to rely upon. Is that understood?
That's understood.
Great, thank you. The plan is, if Mr. Goldstein calls witnesses, we will have the witnesses testify. We will have arguments afterwards. If he does plan to call witnesses, I typically will allow the parties to give brief opening statements solely for the purpose of giving the judges an outline of what the evidence will be, including the testimony and the exhibits that now have been admitted. So now I kind of need to know, Mr. Goldstein, do you want to call a witness to testify in this proceeding?
Yes, Your Honor, I will call one witness.
And your witness will be who?
Rich Gibbon.
Rich Gibbon. Spell his last name for me.
Gibbon.
All right, thank you. Do you want to give an opening statement to give the judges a brief summary of what Mr. Gibbon's testimony will be? It's not required. It's up to you.
Yes, I would. I'd like to.
Okay.
Just briefly.
Hold on just a minute. Before you do that, I want to indicate that if you do keep it brief, less than 10 minutes, I'm sure it will be, and the department will have an opportunity to give an opening statement if it chooses to do that also. All right, Mr. Goldstein,
Just procedural question, just
yes.
as far as how in-depth I should get in this opening statement. After the witness is called, am I going to get to present an additional argument, or is this my time to?
This is not your time to argue. This would be no argument. This would be an opening statement solely for the purposes of outlining the evidence, typically what the testimony is, you expect the testimony to be. This is not your argument. When you're through calling your witnesses, we will begin the arguments after the parties and the judges have an opportunity to ask questions of the witnesses, if there are any. Your argument will be after the evidentiary phase. After your testimony of the witnesses is offered, then you will be allowed a 15-minute argument to start. The department will have 15 minutes to argue. You will have a 5-minute rebuttal. So this is separate from that.
Okay. Then I don't think I need an opening statement right now.
Okay. So you're ready to call your witness?
I am, Your Honor.
Mr. Gibbon? And where would you like him to testify from the witness stand, or would you like him to sit at counsel table with you?
I think I'd rather just sit here, if that's okay.
Can we ask Ms. Hendrickson to move to that chair so Ms. Gibbons has, Mr. Gibbon has, is it Gibbon or Gibbons? Gibbon. Has an opportunity to speak into the microphone. And if you wouldn't mind, Mr. Goldstein, after you give your openings, when you begin your examination, would you just move the microphone toward the middle so you can both speak into it?
Sure.
First thing I need to do is to administer an oath or affirmation to you. Would you stand and raise your right hand, please? You solemnly swear or affirm that the testimony you are going to give here today will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Be seated. And Mr. Goldstein, you can begin your examination.
Thank you, Your Honor. Everybody can hear me okay? Mr. Gibbon, you were the power attorney for Ms. Hendrickson during the audit period, is that correct?
Yes.
Okay. So did you have significant contact with the auditor throughout the audit period?
Yes.
The audit period was for 2009 through 2011, is that correct?
Yes.
Okay. And the best of your recollection, do you recall in around January, February of 2014, agreeing with the auditor that she would look at second quarter 2013 records to assist her with making an assessment for 2009 through 2011?
Yes, as a sample.
Okay, and to be applied toward 2009 through 2011. And you recall what you provided to her, the auditor now, for that second quarter 2013?
All the records, the work orders. She had access to pretty much everything we had access to. She came to our office.
And did you provide her a copy of the second quarter 2013 sales tax return? Do you recall?
She had it.
She had it. Okay. And after she reviewed that return, do you recall the result?
Yes.
And and the documents, I should say, not just the return. And what do you recall was the result of that?
She had said that we had underreported by $15,000 roughly.
Okay. And in response to that, what did you do?
I went through all the work orders and did all the math, and my math was different from what her math was. And my math was what we had filed, in the sense of what the totals were and what the taxes were owed.
And do you recall what the source or the reason for that discrepancy was?
What I found was that the difference between the two, we have motorcycles that come in that have been in an accident, and on those motorcycle work orders, we write it up as an estimate. On the bottom right-hand corner, there is parts, labor, tax, and totals. But if the bike is a total loss, all we do is we write up the tag, but we get towing and storage for the bike. So what that means is that the repair is not done. None of these numbers over here of a total matter anymore. What matters in the sense of our income is we have in the center of the work order, we have right estimate only, towing, storage, and the total of what the insurance company pays us, which is all that's not anything based on resale. It's just the labor of doing the damage estimate, the time that the bike's there, however many days, that's storage, and then what it costs to have the bike towed in, which we did. So what she had done is just ignored this and added up the total amount. So generally, if it's a total loss, that means that the total amount of the estimate of the job exceeds the value, or exceeds 70% of the value of the bike is what they follow. And so these numbers didn't belong in her total. And I pointed that out to her because the number of what I found matched her discrepancy. And I pointed that out to her, that this is damage estimates. They're not jobs. But they're mixed in with everything else because it's still income, if that makes sense.
This was on or about February 2014, and then my understanding is 2 months later the auditor left and closed out the audit. Do you recall if she ever made any adjustments for the 09 through 11 period based on discovering that estimates had been included?
As far as I know, no. Okay. She had access. She didn't come back and go through everything again.
Okay, thank you. That's all I have, Your Honor.
Does the department have questions for the witness?
We do not.
Judge Couey?
I have a question about the work orders and your reported total sales. Your reported total sales were the $123,297 for the 3-year audit period, and I'm just wondering, so on your work orders, did you always separately state the charge for the parts?
Yes.
And so if you add up all the charges, would that equal the $123,000 in taxable sales that you reported for the audit period? Is that your contention, or I guess is that your understanding of?
Contention is that what she was, I didn't go through the whole audit. Is that what you're asking about? The audit period?
I'm just asking how you reported on your sales and use tax returns. So I'm just wondering if you add up the amount of charges for parts on your work orders, does that equal what you reported on the sales and use tax returns?
Yes, on regular work orders. But the estimate, the damage estimates is what I was speaking to. The damage estimates are the same. Tell them this is what it would cost to fix this motorcycle. And so it's written out like a regular work order. But if our total estimate exceeds generally between 70 to 75% of the fair market value of the motorcycle, they consider it a total loss. So that means that this number here, we never get. What we get, and what's on the work order, on the face of the work order, is the cost of the estimate itself, because it takes time to do, and that's labor. The storage, because we charge on total loss bikes, we charge a daily storage and any towing, and then that total is what we are actually receiving from the insurance company. What she had done is she had taken the total over here of the estimate and counted that as if it was an actual transaction, in the sense of that we did put the bike back together, we got the money from the insurance company. Does that kind of make more sense?
Yes, so I guess I'm looking at it from a different perspective. So I understand that the company reported the $123,000 in part sales during the audit period, but then their purchases of parts was over $400,000, so they spent over $400,000 in purchases, but only reported $123,000 in sales. So I'm just wondering if you could help me understand what happened to the rest of the parts that were purchased, or am I misunderstanding something?
In the audit period, or the sample that she took?
For the 3-year audit period, 2009 to 2011, my understanding was there was report that the company reported $123,000 in sales and had over $400,000 in purchases. If I'm not understanding that correctly, feel free to help me understand if that's not correct. And I'm just wondering how to account for the difference between why the purchases were so much more than the reported sales of parts. So I'm wondering if there's an explanation for that.
The only thing that I could, when it came down to what our taxable liability was, is there was a question about markup. And that the markups from what we purchase and from what the customer pays varies. We sell a lot of tires. That's not really based on a percentage rate, but let's say the tire is a $140 tire. We sell it for $170. We put $30 on tires back then. And she was saying that the regular markup is closer to 100%, except that we can't sell them for that. We can't take a tire, buy it for $150 and sell it for $300, because then nobody would buy it, because that's what the market was. Does that kind of make sense?
Thank you.
I do have one question, just a clarifying question. Did you say that you only reviewed the samples for the 2013 quarter?
The one quarter that we went over that she found the problem with.
Okay.
And that's what made me go back through and look at all the work orders and try to figure out what went wrong. And that's what I found, was that the damage estimates were added in with everything else.
Okay, so you didn't review the samples that Ms. Hendrickson provided for the during the audit period?
We didn't. When it came to that thing, I didn't go back and go through all the work orders for that quarter to see if those same things were going on, in the sense of, was she trying to report the damage estimates also? But it seemed to make more sense to me.
Okay, so I just wanted to clarify that you didn't have any knowledge of whether that happened during the audit period with the samples that were given. So
the sample that she was basing on was after the audit period.
Correct. Okay, thank you.
I may have a few questions. I'll give you a chance to also to follow up when I'm through. Mr. Gibbons, what is you said you were the power of attorney during the audit, correct?
Yes.
So were you at the time the accountant or bookkeeper for the business?
No.
All right. But you were the one who worked with the auditor?
Yes.
Yes?
Yes.
Okay. I understand what you're saying about certain documents, and I'm not sure if work orders, I guess. You're saying certain work orders were really not for the sale of parts, may have included lists of parts and costs, but those were for motorcycles that were going to be totaled. You weren't going to do the repairs. You didn't do the repairs. All you were paid for those motorcycles is towing and storage, correct?
Towing, storage, and an estimate fee, yes.
And an estimate fee. Were any of the invoices that were selected for the sample work orders for estimates only?
as part of her sample?
Yes, part of her sample.
Yes.
Okay.
That's where we found the discrepancy.
All right, and do you have, do you know how many of the invoices that were selected for the sample were work orders for estimates only?
Off the top of my head, I don't.
Mr. Goldstein, will you be able to let us know that during your argument?
Not during the argument, no. I would only be able to figure out an estimate of how that would be calculated, but
Okay. Did you, Mr. Givens, participate in the preparation of tax returns for the business during the audit period?
Tax returns, like?
Yes. Did you prepare tax
Myself,
returns for the business? Okay. Who prepared those? If you know. If you know.
if you don't recall, just...
I don't recall. This is a long time ago.
And Judge Quee asked you, I think he asked you at one point how you prepared returns, and I think you indicated that you would go through, I'm talking about sales and use tax returns. Did you indicate that you would actually go through, or somebody would go through the invoices that reflected sales of parts, and you would use those numbers as the basis for your reporting of sales?
But I based it on myself personally, when I would come up just with numbers, was the work orders themselves.
That's how you would determine the amount to report to the Board of Equalization or the department?
Yes, because that's what we sold.
Okay. And did you prepare did you have a computer program that you used, like QuickBooks or something, that you would use to keep track of these things?
No, I'm not. I'm a pen and paper kind of guy. I'm not a really, I would put the numbers together.
Don't recall, you can state that.
Okay. When it comes to who did the actual filing,
I'm more interested in who came up with the numbers to report. And I take it that was you, and you did it based upon a review of work orders?
Yes.
And would you do it monthly and then total the monthly ones for each quarter and report, or would you, at the end of a quarter, go through a whole quarter's worth of work orders?
Probably go through a lot of quarters because I also am a mechanic. So.
Okay. You also worked as a mechanic at the shop?
Oh, yeah. I did lots of things.
When you came up with the numbers, do you know whether or not whoever prepared the final returns reported your gross income first to include all of the income you got from towing and storage and mechanic services that did not include parts? Or did you only report sales tax from sales of parts?
For the Board of Equalization?
For the Board of
stuff?
Equalization.
That's all. That was all based on the work orders. When I say work orders, you know what I mean.
Yes.
It's the job that was done, the parts that got sold.
And you only reported the amounts that you received for the parts sold?
Yes.
Okay.
I would report the total parts number, and then get a total number for that. Sales tax, get a total number for that. Labor, subcontract stuff. Subcontract would be towing or fabrication or anything like that. Does that kind of answer your question?
Yes, thank you. Those are all the questions that I have.
Can I ask
Yes.
another clarifying? Because I thought I had clarified in then
I
Judge
confused it
Guri,
for you.
when you brought up samples and asked the question of Mr. Given about samples, I need to know if your question referred to the audit period samples, the 89 samples that were given to CDTFA by Ms. Hendrickson, or if you were talking about the 2013 second quarter sample that was used as a basis by the auditor to determine that there was a discrepancy. And so I'm asking him more than you, sir, so don't get confused.
Well, hopefully we're on the same page. I was referring to the samples actually used in the audit to determine the liability.
Okay, then I will ask you, you did not review the 89 samples that Ms. Hendrickson provided for 2009 and 2011, correct?
We didn't. I didn't go back through and see if the auditor had included the damage estimates or not at that point.
Okay, so you didn't look for that issue with estimates for totaled out vehicles for those tax years, for 2009 and 2011?
Did I go back through and double check all that? No.
Right, okay. Thank you.
As far as I know, they're part of this whole audit period of time, as far as I can guess.
Okay, thank you.
Judge Quee? Nothing. Does department have any questions?
We do not.
Do you have follow-up that you would like to do, Mr. Goldstein?
I do not.
All right. You're through with your witnesses. You do not intend to call Ms. Hendrickson?
I am, Your Honor. That the exhibit basically is what I wanted to do.
Okay. Thank you. You can remain there if you wish to, or you can have Ms. Hendrickson switch seats. It's up to you.
Just make things easier here.
No problem.
Okay.
We're now at the argument portion. The documents have been admitted. You have some evidence in the record. You're free to argue any of the evidence that's in our record currently, and we'll start with Mr. Goldstein, who will have 15 minutes for his first closing argument. Proceed when you're ready.
Thank you, Your Honor. It's very common practice, obviously, for an auditor to look at the audit period 3 years, but also to seek either confirmation or to utilize information from a more recent quarter, which may be more complete, to use that data to then apply toward 09, well, in this case, 09 through 11, or to perhaps at least confirm their conclusion from the prior period. In this case, what happened is, and these are just the notes, this is all evidenced by the Sales Tax Board. I'm going to call them Board of Equalization. I know the name has changed, but that's what they were back then.
Let me just interrupt you to say, we have full sets of exhibits. If when giving your argument, you want us to look at anything,
I will get there.
Give us the Bates number page so we can go to it.
Sure.
Okay?
So I'm looking at actually the board's page 161 of their exhibit. It's page 10 of 12 of the assignment activity history. It doesn't have the. Do you know what is that? Is there an exhibit number? Oh, I'm sorry. Exhibit E. Exhibit E. And I'm looking at page 161 of Exhibit E. And specifically, I'm looking at February 10th, 2014. And this is where she states she's reviewed the discrepancies found for reconciliation. But prior to that, on page 160, on December 9, 2013, is where she states, the taxpayer prior to that didn't understand why the invoices didn't add up. And then the next page, it's about saying, well, gee, there were estimates included. So the auditor was obviously looking at second quarter 2013 to confirm or use those figures for 09 through 11, and logic dictates that the methodology that she would be using for that quarter would be the exact same methodology she would use for 09 through 11. And in using that sample period of second quarter 2013, it is now discovered that, in fact, estimates had been included, and she looked at all the invoices. There was never a time for 09 through 11 where invoices were not looked at. So when we talk about a $444,000 figure, that's a conclusion based upon an erroneous base in that if she was using, which again logic dictates for second quarter 13, she'd be using the exact same methodology to confirm her numbers for 09 through 11, she was using estimates for work never actually sold or performed, just an estimate. And so what that means is that she was using estimates for this whole time because she didn't change her methodology. She's not here, obviously. She's no longer with the board, and that's actually another important point is that this is February 10th, 2014. We discovered the discrepancies and the reason for them. And then basically on April 25th, she's basically saying, I think it's April 25th, hey, I'm leaving the board. I'm no longer going to be here, and I'm just turning in my audit report. And there's no indication that between February and April that she ever went back and changed or reviewed any of her prior methodology to see if, in fact, estimates were included. And what we've included in our exhibits, Exhibit 2, are these just a sample of the estimated invoices. There are more. So many have water damage and literally could not be copied, but they are available for review in person. But these are estimated work orders that for work was never done. So if you're taking these numbers, which just these alone, and this isn't a complete set, is $90,000 worth of work as a sample, that's been used to confirm that, in fact, there were higher sales, or the $444,000 base that we're using is saying, hey, these were extra sales. Well, they weren't. And again, the methodology that she used for second quarter 2013 didn't catch that. That's my initial response, Your Honor.
All right, thank you. Department, 2 questions. One, are you ready to give your only argument?
We are.
And do you intend to state any factual matters in your argument that might require me to administer an oath or affirmation? Or alternatively, just bear in mind that factual statements and closing arguments are not considered evidence, and you can just proceed.
Mr. Hanks will provide factual information as well as I will.
All right, and how do you want to handle that?
At the time that that comes up, that you can swear us in.
All right, or if it's during this argument, it probably makes sense just to administer an oath or affirmation now, and that way you could call on Mr. Hanks to verify things anytime you want to. Bear in mind that Mr. Goldstein will have an opportunity to examine, and the judges will have an opportunity to examine Mr. Hanks regarding any factual statements, okay?
Sure.
Mr. Hanks, would you stand and raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth? Thank you. You be seated. And I take it that you're going to just give your argument, and then when you get to a point where you wish to elicit some factual information from Mr. Hanks, you'll do that?
Yes. I was going to provide some factual information. There was an exhibit provided regarding the subsequent. It hasn't been argued, but I was just going to give a brief statement on that.
Factual information.
Yes.
Then you should also stand and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated. Same caution that if you testify to any factual matters, I'm going to allow Mr. Goldstein to ask you questions, and the judges will also have an opportunity to ask you questions. Mr. Goldstein, yes?
Yes, just to avoid confusion, can we just set aside time when just the facts are being discussed? Because I don't want to misunderstand what fact and argument.
I have a feeling that there's not going to be that many facts testified to. If I feel like there's a lot of, the department's got 15 minutes, I'm including whatever facts they want to testify to in that 15 minutes. I will keep a rough track of how much time is being used for the factual testimony. Do you need to have it tracked in any more careful fashion than that, Mr. Goldstein?
No, go ahead.
Yes, Chief.
Mr. Goldstein, do you need anything more than that?
Well, let's see how it plays out, and that would be great.
All right.
Just to clarify, my facts will be just in regards to the now subsequent audit, I guess you'd call it an audit, and Mr. Hanks will just discuss what we would expect for this type of business. So those will be our 2 facts that we're presenting.
And are you going to ask Mr. Hanks the questions, or is he going to just testify in a narrative fashion?
He's just going to testify in a narrative fashion.
When it comes to the point that you are going to give that testimony, Mr. Hanks, I want you to give us a brief summary of your background so that there's some kind of foundation laid for you to make whatever statements you intend to make about this type of business. Okay? All right. Department, you can begin your closing.
Okay, thank you. This particular audit is of a motorcycle repair facility. They also have some other operations that are conducted here, but that is separate from what we're discussing here, or how we calculated the liability. The audit was for the periods of the years 2009, 2010, and 2011, which were filed on quarterly returns. When conducting the audit, there was a large difference between the amount of gross receipts reported on the income tax returns and the total sales that were, or the sales that were reported on the sales and use tax returns. What was particularly we looked at was the amount of purchases compared to the amount of taxable sales reported on the sales and use tax returns. So that there was a substantial difference between gross receipts and taxable sales that were reported. A lot of that was income non-taxable from either towing or repair facilities or the repair of the motorcycles. So there was no sales journal. There were limited sales invoices. They didn't appear to be complete. If you look at Exhibit B, page 8, which is a summary of the sales tax returns, what you'll find on there is that there's very small amounts of taxable sales that were reported during the early periods of the audit. In fact, if you look at the purchases, or we looked at the purchases for the second quarter of 2009, they had $108,000 in purchases, but they only reported taxable sales of $3,800. I should, the 108, and actually it was 113 total purchases was for the entire year of 2009. There were some adjustments to be made, but I'll explain that. So what the auditor did was basically impeach the records. What they said was the total amount of purchases in the audit, which was $408,000, was significantly higher than the reported taxable sales of $123,000. And the only way that we could determine how to figure out the audit liability or the amount of taxable sales was but what we call the markup method. So what we wanted to do was take a representative period of time. We take a look at the sales invoices and we compare those to the purchases of those specific parts. So since the second quarter of 2013 was the most complete, we decided to take a look at that particular period. And what we came up with was a almost 45% markup for that period. Now, the appellant has argued that there were estimate only. The department would agree that if there's no sale of tangible personal property, there is no sales tax that's due. So just the fact of giving an estimate, getting a tow, having storage, there's nothing taxable from that transaction. So the issue is that the taxpayer did bring up there were estimates only, and that if you do take a look at our Exhibit E, page 10, going back to that, which is February 10th, 2014, the second paragraph, second line to the bottom of that paragraph, it says, since they were not clearly identified on the actual invoices, that they were estimates. So as you can see from the information that's provided with the appellant's exhibits, you can clearly tell on those sales invoices which ones were estimates or not. It's written on the invoices themselves. But I think the point that I'm really trying to make is that even if you did list those sales down and we thought they were sales, that in fact those would have been the prices that you would have charged and you would have had the purchases, I don't believe it would change the markup, other than to say that if in fact we knew that they were estimates, we would not include them in our markup. So with that said, the taxpayer disagreed with the use of our second quarter of 2013. They felt that the markup was too high. Our alternative was to come back to the appellant and ask them to provide us at least 20 sales invoices for each year, and the purchases, corresponding purchases that go along with that, and that we would then use that as the markup test. And in fact, that's what we did. So the information that we're currently using is information that was provided directly by the appellant to us in order to calculate that percentage. This isn't something that we picked out ourselves, but what the appellant provided to us. And what we found was in 2010, they only provided us 5 invoices that we didn't feel that were taxable, and therefore we didn't use them. But the markup for 2009 was 41.5%. The markup for 2011 was 40%. We basically took a weighted average of those two and came up to 40.91%. And now I'll have Mr. Hanks provide his testimony as to whether we consider that to be a reasonable markup or not.
Good morning, Judge Geary. I'm Kevin Hanks. I'm currently the Chief of Headquarters Operations Bureau within CDTFA. I have approximately 35 plus years of experience in working for either Board of Equalization or CDTFA in a capacity to review audits as they get generated, also to review audits that find themselves in the appeals or petition process. So throughout my career, I've probably examined 1,000 plus audits, many involving the use of indirect audit methods such as the one used here, the market method, to establish what audited taxable sales are. In my experience, I've seen markups of this type in related industries with the markup of approximately 40% for the sales of parts related to parts sold for repair parts for either motorcycle dealerships or automotive dealerships. This is a reasonable markup that we traditionally see when we examine books and records of this type of business. So this markup isn't unusual in the sense that the 40% calculation was verified over different periods. I think corroborates the reasonableness of the 40% markup. Moreover, I believe the taxpayer's own estimate of what that markup should have been, between 30% and 50%, more or less corroborates the validity of the 40% blended average markup that we've calculated and used in our estimates.
I will give you an opportunity to examine Mr. Hanks after the argument is completed by the department, Mr. Goldstein.
Okay. So what we did in this particular case is take the purchases that, and we went through each one of the purchase invoices to obtain these purchases. The appellant went through there and took out some of the items that they said were non-tax or non-purchases. So the $408,000 was obtained on a individual specific basis. We used that amount. We made an adjustment of 2% for shrinkage. In fact, it may not have been sold, taken for whatever particular reason. And then we applied the markup of the average markup of 40.91% to come up with what we say were the sales of tangible personal property during the audit period. And we compared that to reported, which was $123,000, and we came up with a difference of $440,000. That's essentially how the audit was calculated. I would point out that there was no evidence that any sales of tangible personal property were exempt for any reason. So there were no resales, no out-of-state sales, no information of that was provided. So this, and I would direct you to Exhibit D, page 1, second to last paragraph, in that when we did the audited amounts from this audit period,
we came up with 46,663 was the average quarterly figure, and what they had been reporting subsequent to the audit in the next 8 quarters was 45,272. So it appears that the estimate that we came up with was close to the amounts that they started reporting in the 2 years subsequent to the audit. Now this will be the testimony in regards to the now that was provided. And essentially what it was is there was a subsequent audit that was selected for the taxpayer. Did you want me to give my qualifications, or is that?
Sure.
Okay. I have 38 years, or over 38 years of sales and use tax experience as an auditor, as an audit supervisor, as a criminal investigator, and also as a hearing representative. And I've dealt with these type of issues and markups for the last over 10 years in particular. So anyway, the now they were subsequently selected for audit. The auditor went out to conduct the audit, which is a different auditor than the original auditor. They took a look at what the taxpayer was reporting. They used the estimate of the 41 or close to 41% markup to see if what they had been subsequently reporting was consistent with that. Their determination was that it was close enough, and the auditor decided not to conduct the audit. So it does appear that the reporting had changed since this particular audit period, and that the taxpayer was now in compliance with the their reporting. So I think I've covered everything, and with that, we conclude our presentation.
Thank you. Mr. Goldstein, do you have any questions for either of the witnesses to the extent that they testified to factual matters?
I do, Your Honor. I'll go with Mr. Hanks.
Sure.
So I have actually several questions. Would you agree that starting in end of 07, 08, there was a Great Recession, as it's now known?
Yes.
Okay. And from your experience, did a lot of businesses go under?
Yes.
Okay. And did a lot of businesses slow down and have very much lower sales than they had in the prior years?
What we've seen is generally the businesses, some businesses had markedly fewer sales. What we didn't find was that the markup on the individual sales items varied, but the overall gross sales may have certainly diminished.
And I'm just talking in a business sense. I'm not talking about anything else. Yeah. And would you say that subsequent to 09, 10, 11, actually the market started improving around 012, correct?
Correct.
And 13 was markedly better?
Correct.
So to use 13 as some sort of sample for 09, 10, 11 would actually not really be very accurate, would it?
No, I disagree. For the reason that I stated before, generally speaking, the sales volume isn't an indicator of what the markup is. The markup tends to remain consistent from year to year. So actually looking at markups from 2013 should be consistent with those found in earlier periods. Now, the sales volume, total sales volume, may be different in those periods for the reasons that you've described, but the markup actually remains consistent.
Okay, so let's focus on markup. Let's talk about a weighted markup. Now, I'm going to talk in general, then we'll talk about this business. If I go to Starbucks and I order a cup of coffee, the markup may be, what, 400%? 200%? Would you agree?
It could be high, yes.
Something
yes.
like that. I mean,
yes.
we're just...
Yes.
And if I buy a muffin, perhaps it's coming from a third party at Starbucks, but the markup may only be 20%, correct?
I doubt that it would be 20%. It's
Give
going to
me a
be
number.
higher, but probably different than the coffee sales.
Just for fun, you can give me a number of what you think it would be. A muffin markup.
150%.
So coffee's got to be 400%, right? I mean, if what does it cost, a nickel, and I'm paying $1 or whatever that is. What is that? 20? What is that?
Yeah, so I wouldn't want to speak, regarding what the markup
Just
may
for
be
fun.
for a business.
Okay, but let's just say we have a markup of 200% on one item and a markup of 60% on another.
Right.
Now, if I just combine those and I divide by 2, and I say that's the markup, is that an accurate way to determine a markup for an entire business?
What we would say is that using more of a weighted calculation would be more appropriate, which is similar to the methodology that was used in this audit. Because what we find is that there is a variance in the markup on sales of individual property. So, for instance, a filter, an oil filter might have a markup of 40%, but a gasket, might have a markup of several 100%.
Okay, and did you figure out how many tires were sold during these years?
I don't believe that we had access to that information.
So if in fact tires, which may have the lowest markup, if you don't have access, you actually can't properly weight the markup if you don't have access to it, correct?
No, in the sense that if we are looking at, say, 20 representative invoices from each test period, then actually there could be a combined weighting within all of those amounts. As I say, the markup for individual products is going to vary. If we look at our audit working papers, we'll see that. We've got very low markups on certain sales of product, very high markups on other. So getting a blended markup and combining those selling prices actually gives you that weighted markup.
Okay, but your prior statement was you did not have access to those records. Is that correct?
No, we had access to sales invoices that the petitioner provided to the audit staff. They mirrored those with the purchase invoices that we saw for that property, so we could calculate what the markup was based on the selling price of that property.
Okay, I'm just confused though, because when I asked if you had access to the tires, you said no, and now you're saying you did have access to records to figure out a markup.
We requested sample invoices from the taxpayer, and those were provided for the tested and sampled periods.
So you did have access. So your statement that you did not have access would not be correct.
No, what I indicated was that I don't believe that the records were sufficient where we could identify the number of tires sold by the business over the 3-year audit period.
But you did have access to the records. They're apparently not sufficient, and so basically we could not have an accurate weighting then because we don't have access to all the tire records. Is that what you're saying?
No. So what I'm saying is that based on the available invoices and both sales and purchase invoices that were supplied for the test periods we sampled, that we're able to calculate a weighted markup of 40% that Mr. Lambert described.
You were not at the audit itself, correct?
Correct.
So for the auditor to create this markup, this analysis, and then use it, do you know exactly what she was looking at? I know you're saying purchase invoices, but she looked at sales invoices too, and can you be sure she wasn't just relying on sales invoices in the end?
It's my understanding that she was looking at both or had access to information that confirmed in her mind what the cost price was for the sales reflected on the sales invoices.
Okay, so if she's looking at both, it's certainly possible then that she relied heavily on the sales invoices. We actually do not know for certain.
She relied on both the purchase information and the sales information from the taxpayer's records.
Okay, so the sales information, we know from second quarter 13 when she did the review that it included estimates, and I know there was testimony that apparently they were not properly marked, but as far as we know, all the invoices have always been prepared the same way, and there's a lot of information on these. So it's actually pretty tough to tell that it's an estimate. Can I show you an example?
Are you showing the witness now an example of something that's already in the record?
It is,
Can
Your
you
Honor.
refer us to what, so that we can look at what you are going to be showing the witness?
It's page 1 of Exhibit 2.
And the document you're showing the witness, is it the exact same document that you submitted? There's been no other notations made on it?
It is, Your Honor.
Thank you.
You know what? I shouldn't say that. It's highlighted. This is an original, so probably on the photocopy it wouldn't be highlighted.
Okay.
But I don't think that makes any difference in what I. So would you just take a look at that?
Mr. Geary, I think we would object to my making comment with respect to these invoices. And my area of expertise was just testifying with respect to the markup and whether that markup was reasonable for this industry type. Mr. Lambert could provide more detailed information regarding the invoices and how the selling prices were determined.
Hold on just a minute. I want Mr. Goldstein to have an opportunity to reply.
Mr. Lambert, you testified earlier that.
Just a minute. We have a pending objection to the line of inquiry. The grounds being, if I understood correctly, that's essentially beyond the scope of the direct testimony from this witness. And I believe Mr. Hanks indicated that he would defer to Mr. Lambert, who has more detailed knowledge regarding the specific invoices at issue. Is that a fair statement?
That's correct.
So what's your, maybe if you helped us on the.
I'm happy to question Mr. Lambert instead.
That's up, or you could explain where you're going with this. If the department is indicating the information is better, the questions are better directed to Mr. Lambert, and you're willing to do that, I'll allow you to ask Mr. Lambert the questions.
Okay. Sure. I'll have a few questions for him. On the invoice, you said it seemed clear, not clear on the Q2 of 2013, but you seem to indicate that for 09 or 11 it would have been much clearer. You're taking a look at the invoice. There's a lot of information. Is that an original invoice or is that an estimate?
It says it's on a repair order and it has a number 5526. On here, it would show the amount of 9 days of storage, $337.50, and the damage estimate of $65, and would show $402.50. There was no billing for labor parts, the total. So I would say this is an estimate.
Okay, and thank you. I can take that back. I would like it noted for the record that it did take him time to try and figure that out. I'm going to give you another. This is page 3 of Exhibit 2. Can you tell me if that's an original or an estimate?
I did figure that out, and that's what an auditor does when they do an audit. Is they don't jump to a conclusion. They.
I don't need you to explain it, Mr. Lambert.
What's that? On this one, it indicates the same thing. There's a storage 9 days, $337.50, $65 damage estimate. I don't see on here where the parts are broken out. I see a billing for the parts. It says $34.45, but we wouldn't be able to use this for a markup test because what we would need is to have a specific amount here. And in each one of these cases, we had a sales amount that was listed on here, and we also had a corresponding purchase invoice that we traced the amount to. And what I would point out again is that we did not use the markup from the second quarter of 2013. In fact, we used the markups from 2009 and 2011, an average of those, and those were the invoices that were provided directly by the appellant. So there's no evidence that I have that any of those were estimates, and I would have to question why they would provide those sales invoices to us, or repair orders, that would have estimates on them. So I guess that's my
Maybe you could try to limit your responses to the questions. Things might move a little bit more quickly. And then when he's through questioning, if you have clarification you want to give, you can give that, okay?
Okay.
Well, I would like to follow up on one question for an issue you raised. You stated that you don't know why they would provide all the invoices. I believe the earlier testimony, or I think it was testimony, was that the board believes that certain invoices were actually missing. Is that correct?
When you say invoices, sales invoices were missing. That's correct.
Or out of order?
I believe they were missing.
But how would they, because of numbers, or how would they know something's missing? If how do you prove a negative if you're not going by a number?
Right. So what you would do is you compare to the reported sales of tangible personal property compared to your purchases, and in addition to that, there were also gaps in the invoices, the invoice numbers. So there were two sets of invoices, one for repair orders and another one for what they call half sheets, which appear to be sales that were over the counter. So both of them appeared to be missing. They weren't in sequential order, the ones that were provided.
So you would need to provide these estimates, though, in order to be as sequentially accurate as possible, correct? I mean, if you're looking at sequences to try and determine if we have everything, then you would need even estimated invoices to do so.
Right. You would need the estimated invoices if you were trying to confirm that all the sales that you had reported were supported by the actual invoices. If that was the method that we were using, I would agree that we would want to account for each one of those sales invoices.
Okay. And at a motorcycle repair shop, I imagine there's a lot of receipt books running all around. You got people with grease on their hands, running between equipment. Just from your experience, wouldn't it be common for somebody just to pick up whatever invoice book is there, and maybe they're maybe not sequentially in order all the time, but just pick up what they happen to have in their hand at that moment in time?
I don't know about maybe common. Every place has a different way of doing things, and it really depends on I guess the bookkeeper and how you're billing things. If it's a smaller shop, it's more likely that they would have a sales invoice that they were filling out. If you have a bookkeeper, a lot of times you might have somebody with estimates, but they would be the ones that would provide the actual repair order or sales invoice.
Okay, and I'd like to just give you one last exhibit here. This is, I believe it's page 6. On the top, it's invoice number 4896.
Page 6 of your...
of my exhibit number 2, I believe. Is that lining up? I might have moved them out of order, but it's top of the left is number 4896.
Yes.
Okay. And can you tell me if that's an estimate or an original, please?
Estimate original, but...
I don't mean original, sorry. An estimate or an actual sale?
Well, there's an estimate that's given on there. Did this sale actually take place? Is that the question?
Yes.
I would say based on this that that it did not. I mean, one thing that you would have to go to, if in fact that's what you were trying to do, is to go to the receipts, your receipts journal, to see what amount was listed in that, what was deposited into the bank. This by itself, although it lists each one of the parts items and it does give a price for that, you would have to see what was paid. If I had to, I guess at this point, guess, I would say it was an estimate.
Okay, thank you. So I'd just like to confirm that, in fact, when the auditor went through second quarter 2013, she actually didn't pick up whether it was an estimate or not. Her first reaction was no, correct? Meaning, sorry, not no. Her first statement or conclusion was that all of these were sales.
As far as in her, the calculation of the markup for the second quarter, because there's two different things that you're discussing. The one issue is when you went through, what she did was she specifically went through for the second quarter of 2013, and she added up each one of the individual sales. And so when you, and it's in the exhibits here, I don't have it off the top of my head, but it's in here where she went through each one of them and listed it. And I believe that is the issue, is like, why did you come up with a higher amount for the second quarter of 2013? What I would point out is it's outside the audit period. But as far as the amounts that were, or the repair orders that are included in the markup test, I don't have any information to show that she included sales that were that didn't take place.
Okay, so we can just confirm that, right? We can't confirm it one way or the other whether she used majority of sales invoices to rely upon her markup, or not markup, but her gross sales, or just a purchase order, because her notes say it's sales, purchase, and frankly, from the second quarter, she didn't look at the purchases, she just looked at the sales and found the discrepancy.
No, I'm not sure exactly if I followed your question, but if you're telling me, did she just use the added up sales to calculate the liability? That's not what happened. She took specific repair orders and used the parts listed on those compared to the ones where she was able to find the purchase invoices. That's how she calculated the 45%. The other figure, when she went through and just added up all the second quarter 2013 sales invoices that or repair orders, she didn't do anything with that figure. And in fact, she didn't do anything with the 45% either, other than to say that there appeared to be a problem with the reported sales.
All right, well, she left like before she could do anything, right?
No.
It was just 2 months later. I mean, if there was a major discrepancy in 3 years of audit material, not enough time to figure it out, is there?
No, well, the way our audit program works is that you should be able to document everything that you do, and that somebody should be able to come in after, or if you happen to leave for whatever reason, that someone could come in and step in and take over what you had done. So the fact that she left, I don't think has any bearing on the audit itself.
No, not that, but, well, not how she did it and where that is. Sorry. My point being is that if she based part of the audit on, or confirmed her figures from the sales invoices, that according to second quarter 2013, she made an error.
No, I don't.
No? Okay. So you wouldn't agree that she included estimated invoices either as part of her markup or as part of her sales initially?
I don't have any evidence myself that that's in fact what happened.
Well, the notes say here, she says, we found a discrepancy and we asked the taxpayer about it, and the taxpayer came back and said, oh, you've been including estimated invoices in your calculations.
Yeah, I believe that's in regards to, and I can find the schedule where she added up the second quarter of 2013 sales invoices. I believe that's what the comment is in regards to, is that it's the total that she did, and it's completely separate than the test that she conducted for the second quarter of 2013, other than she did use, on any particular invoice, she did use the listing of the parts.
For markup only?
To calculate the markup.
And that part was sold?
And that part was sold, that's correct.
Okay. So if there was estimated invoices in there that were never actually sold, believing that the parts were actually sold would actually be a mistake.
I would say if that's in fact what happened, and I'll just talk hypothetically, if you had an amount that was included in there that was a sale that didn't take place for markup purposes, you shouldn't include it in your test. With that said, the amount that was being listed on there is what you would normally charge for that particular part, and so with the corresponding purchase invoices, you shouldn't have it in there, but it really shouldn't affect the test because that was a sale that could have taken place. Now, if your argument is that it's an amount that was exaggerated, which I don't believe you would provide that to an insurance company, then that's a different argument.
Right. But if you were using the sale invoices as confirmation that you believe something was sold, because again, actually, it doesn't sound like the auditor had all the purchase invoices, but if you're using the sale invoices to confirm that something was actually purchased, when in fact it wasn't, it would impact a conclusion, correct?
Yeah, well, just to correct or clarify your statement, I believe we had all the purchase invoices. We're not arguing different than that. In fact, all the purchase invoices that at least we're marking up are on our schedules, and each one of them is listed. So that information is present. The second quarter of 2013 was used to calculate a markup, and just to point out again that it was not used, and so therefore it was just used to determine that the amount of sales reported on the sales and use tax returns were understated.
But when second quarter 2013, her sample be generally how she would have considered the audit for 09 through 11? Her process?
The markup test? It would be.
I'm just talking about. I'm just saying she found discrepancy. So if she believed there was discrepancy for 09 through 11, then perhaps everything else is just confirmation bias.
I don't know how you. I guess my answer is no.
That's fine.
Yeah, Mr. Goldstein, I think
we're
probably
we're good.
You should be getting close to making your
argument.
Oh,
that was my last question. You're
okay,
right.
Good. The generally allow 5 minutes on a rebuttal.
I'm okay, Your Honor. I think we've got everything out there.
You don't wish to do any rebuttal to the department's argument?
Well, sure. I'll give just 2 minutes here.
Right.
Yes, I do think there is confirmation bias in this case. I think how she did second quarter 2013 is indicative of how she considered 09 through 11. I think she included sales that never actually happened, and I think however she did try to confirm her methodology would, again, just lead to confirmation bias of saying, hey, there's underreporting because I see invoices that show more sales, and there must be a reason for it. Also, there's there hasn't been a proper weighting of sales. Yes, oil is going to have a higher markup than tires. Tires has the lowest markup, but tires also have the higher cost. I mean, a can of oil is $5. A tire can be over $100. So I also don't think the board has equally weighted it. There's been no accounting for any inventory in this. They just did 2% spoilage. That's certainly not enough because they don't even have an inventory that's just sitting on the shelves, and that's not acknowledged at all in their spoilage. So that's really all I have.
I'm going to allow my fellow judges to ask some questions generally about your arguments, if you
Sure.
don't mind.
Yeah, so I understand there's been a lot of discussion and that there's a dispute about the audited taxable sales based on examining the sales invoices, but I'd like to just take a step backwards and make a big overall understanding to make sure I understand this case. And it's the taxpayer's position, if I'm understanding correctly, that the originally reported amount of $123,000 in reported taxable sales was correct, and they stand by that figure. Is that a correct understanding?
We don't have any information to say that it's incorrect. I mean, other than I think assumptions that are based upon records that are not actual sales. But is there is there a middle ground here? Sure, we can make that argument that if you take out the estimates, that they shouldn't be included.
Okay, and so my understanding of the CDTFA's position is that they didn't originally accept the 123 figure because they determined that the that the purchases of motorcycle repair parts far exceeded the amount of reported taxable sales of motorcycle repair parts. Was that the findings of the initial determination?
I think ultimately that you're correct in that they reported $123,000 and that they had purchases of $408,000. Now you can have as many, estimates or sales that didn't go through, but something happened to that. 275, probably more than that because the 123 is a marked up figure. If you marked it down, it'd probably be over 300,000 in purchases that don't show up. So it's our contention that in fact you purchased those, you sold them, and it's not on the sales invoices, and we have to go to the markup method in order to determine what the true sales were.
Okay, and just so I understand the taxpayer's position, do you dispute that you made, or not you, but does the taxpayer dispute that it made $408,000 in purchases and that number was far in excess of the reported taxable sales, or do you agree with that and have some other explanation for the discrepancy?
Yeah, I'd have to see how he's coming up with the 408, but yeah, I thought he said there was $100,000 of purchases in 108, and then he corrected to I think 113 for one of the years. So, I don't think, and that was total for his numbers. I don't think it's 408 the underreporting of actual purchases in dollar amount.
So I guess on Exhibit F, page 5 of 7, it shows 113,000 in audited purchases for 1 year, 121 for 2010, and 173 for 2011. I assume that comes to the 408. I'm not sure. I was wondering if you're disputing that you made those purchases or the taxpayer made those purchases, and if so, if you have a basis or evidence for why the purchase calculation was incorrect, because I understand you've had a lot of testimony on the dispute with the sales invoices, but I'm not sure if I heard a dispute regarding the purchase invoices.
But you're looking at Excel spreadsheets, right?
It was Exhibit F, page 5 of 7. It was just a summary of the audited purchases.
Right, but that's if the input's not based necessarily on the purchase invoices, but has also been based on the sales invoices, which we just don't know, it would actually show up at that. Sure.
Okay. I think I don't have any further questions. Thank you.
Any questions?
Yes, for Mr. Hanks, I did have a question. So you testify that this would be the kind of markup that you'd expect, but even with 35 years of experience,
Right.
where do you get, off the top of your head, a motorcycle business that has an associated towing company that's in the specific geographic area and operated by a sole proprietor? How do you guys, does CDTFA have databases that they go to figure out what an average markup is in a particular area and in a particular geographic center?
Right. We don't have databases that we necessarily look at. We do have information on all the audits that are performed, and so we could actually look at different industry segments within different geographical areas and look at those audit results individually. I'm speaking from experience of having looked at many hundreds and thousands of audits for areas throughout the state, where what we typically find is the markups for this industry don't vary all that much. Markups for, say, a restaurant industry will vary depending on geographic location. So if we're talking about restaurants in the Bay Area, for instance, we'd probably need to pull some of the audit results from areas within that area to determine what an overall blended markup is. But for this industry group, we find that the markups are relatively consistent. So I'm speaking from my knowledge, my personal knowledge of seeing audits of this type that are in dispute, where we see markup calculations made of weighted average markups on the sales of parts.
Okay, and just to determine even the relevance of it, if I'm understanding this correctly, and this is for either of Mr. Lambert or Mr.
Hanks.
Hanks.
Yeah.
I almost called you Franks. I'm sorry. If I'm understanding it correctly, the 2013 sample was only used for two purposes in any event, and the first one was to determine that there were discrepancies in the records that would lead you to do a further audit. That's one, correct?
Well, kind of. What we intended to use that second quarter 2013 markup to calculate the liability. So it was only when the appellants disagreed with the results of that we decided to take figures from inside the audit period. And the reason why we took the second quarter 2013 is because we felt that it was more complete, that they had the sales invoices for that period and they had the purchase invoices, and so that's why we used that. It wasn't until they raised an objection that we decided to then have them pull the sales invoices they wanted tested and the purchase invoices, and then we calculated the markups from that. And what I'd point out is that the relative markups between the second quarter 2013, 2009, and 2011 are fairly consistent, but that the lower figures were from 2009 and 2011, and that's what we used to come up with our average.
Okay, so intent aside, you didn't end up using that quarter to determine the bottom line markup, right?
That is correct. There was nothing in there that ends up in any audit calculation.
Okay, and then the second reason that I think I'm understanding that you use that is the same reason that you use the estimate for the industry is what I call a gut check or a validity test to see if it closely equates or substantially equates with the actual results from the audit.
That's correct.
Thank you.
Further questions?
All right, thank you. This concludes the hearing. We, the judges, will take it under submission. The record's closed. Generally, within 100 days, we issue our opinions. Copy will be sent to the parties. And thank you again for your participation this morning.
Thank you.
Thank you.
Hearing's adjourned.